Well, first thing I'd say is I'm very disappointed in the outcome of our port challenge. It is still the case that the development will be emitting over 500,000 tonnes of greenhouse gases per year, and which, just to give your listeners some perspective, is more than all of the greenhouse gases coming from the entire cattle herd in County Clare. So it raises questions of justice as to why one development should be allowed to increase emissions by 500,000 tonnes, and then the other sector, the agricultural sector, is being told to reduce emissions. But leaving that aside, an interesting aspect of the judgment that Judge Humphreys made clear was that he was ruling on the legality of the planning decision. And he wasn't saying whether the decision was correct or not from a physical point of view, in other words, in terms of climate impact. And I can say emphatically that the decision from that point of view is not correct. The climate impact exists, and it can't be waved away by appealing to purchase of renewable energy.
So do you think the climate aspect, the environmental side of things, is taking a backseat?
Well, as the judge pointed out, he said he was only ruling on the legal aspects. In other words, were the planning authorities legally entitled to grant permission? And he concluded that they were. He wasn't saying that there won't be a climate impact in terms of the greenhouse gases in the atmosphere. But we're dealing with the appeal was against the planning decision, so they have permission now. That's undisputed, and it's conditioned on the ART data centres purchasing renewable electricity, such that the energy in that renewable electricity matches the annual energy demand of the data centre. Now, and on that basis, the planning permission was considered to be legal. Now, the difficulty here is for our data centres at the moment that it is simply not possible for them to source additional renewable energy of that magnitude. It's a huge amount of energy they'd have to source. Just to give you an idea of it, if you think of all the wind turbines in County Clare, if you multiply that number of turbines by 3, you might produce enough additional energy to power this data centre.
So the infrastructure doesn't exist to generate that amount of electricity?
Well, you'd have to put up 3 times the number of wind turbines that we have. So it wouldn't be possible to do that in a short time frame. It would be just physically impossible. So what ARC data centres will do, presumably, is go to projects that already have planning consent throughout the country. Some of them are in County Clare, some of them will be Galway, Mayo, all over the country. They will find projects and they'll offer to buy the power from those renewable energy projects. Now, that's of no benefit to the state because those projects would have happened anyway. The power would have appeared on the grid, but the ARC data centre will claim that as an offset for their emissions. Out there in the Tuller Road, they still have a power station operating, which will be physically emitting nearly 500,000 tonnes a year into the atmosphere, but we have to pretend that doesn't exist because they purchased this renewable power elsewhere. So it's like the old days of indulgences for sins, purchasing indulgences to wipe away sins. They're going to do purchase of renewable electricity, which would anyway have appeared on the grid, and they're going to say, well, that makes the emissions zero from the Ennis site, which it doesn't, because physically you'll be able to go out, you'll be able to see the stacks, and you'll be able to see the plume of gases coming out of it. So it is legally correct, put that way, but physically wrong.
Yeah.
So the decision from the point of view of climate protection is actually just totally wrong. There's another aspect of the renewable requirement for corporate power purchase agreements, they call it. It's when a big company goes out and does a deal with the wind energy companies and they purchase their electricity on a contract for 15 years. The ARC data centres, if they do that, they won't have any exposure to carbon costs, which the rest of us have in our bills. If you look at your bill, part of that unit price is actually the cost of purchasing the carbon allowances for the fossil fuels for generating the electricity. ARC data centres will be exempt from that. But the emissions will still occur from the power plants that supply the grid, and they have to be paid for, and that cost will be transferred onto the general consumer. And I work out that if ARC data centres goes ahead with this and purchases matching renewable power equal to their energy consumption, there will be an extra cost of 50 million euros per year passed on to the general consumer, which will put up electricity prices.
Colin, just finally on this obviously is the end of the road for your challenge of this data centre and the overall challenge, but what kind of precedent do you believe it sets for developments of this nature around the country?
The judgment in the court, in the High Court, opens the floodgates basically for similar developments. That's to put it in a nutshell. And the decision by the Commission for Regulation of Utilities is that all new data centres, if they're going to connect to the grid, have to have their own on-site power generation, something like our data centres have planned. So it's actually downhill from here in terms of our climate targets. The High Court decision and the Supreme Court decision earlier on the Coolglass wind farm essentially has gutted the Climate Act. There are no protections there at the moment. We know we won't reach our targets, but it will be quite difficult in the courts for us to challenge future projects because of the interpretation given to the Climate Act by the court. In other words, a planning authority can basically do what it wants. It can ignore the emissions from a project and grant planning permission. So we're very disappointed in that. We'd like the whole climate action plan to be based in reality and not on kind of legal subtleties.